Before we get started, make sure you subscribe to our channel. And if you're on YouTube, make sure you click on the bell notification so that you get notified of all of our upcoming videos. All right, so I am here with Fawad Khan, and I've known him for probably a good maybe 5-6 years around that time. Yeah. And he's worked on a couple of my transactions, and he's one of the few attorneys that I believe know what like how to deal with investors. And so, why don't you explain? Why don't you tell me a little? Tell everybody about how long you've been practicing and.
Sure. So I've been practicing for about 7 years now. All of that's been real estate. So real estate is all I do. That's the only practice area I have, and out of that, majority of my clients are real estate investors. So I do have retail clients, but I try to focus my business on serving real estate investors. Everyone from flippers to people doing long-term holds to wholesalers. That's sort of been my focus is structuring deals for real estate investors.
I'm sorry to interrupt. Do you do like commercial as well? Or?
Yeah, I do commercial, residential. So
okay.
I do everything from large apartment buildings, commercial buildings, to mixed use, to multi-units, or single-family residentials.
Okay, and just a little background, I guess. Where did you graduate from law school?
So I went to Rutgers for undergrad, and then I went to Quinnipiac University for my law school. I graduated from there, and right after I graduated, I essentially just went out on my own, opened up my own law firm, and I've been doing
nice.
Real estate since. Sort of started doing real estate closings. I found it to be what I liked. I like transactional work, and then sort of just grew it from there.
Nice. How long have you been practicing so far?
7 years now.
7 years.
Yeah, 7 years now.
You've come a long way.
Yeah. I've been lucky, and then it's also just getting out there, getting to meet people, and sort of just growing the business. So yeah, that's what we're all about.
Cool. So I'm here because I want to grill, not grill, but really ask questions that I think a lot of investors want to know, and really, because especially when even if you're new or you've been in this business for a long time, there's always something new that you learn.
Yeah.
And so I wrote down some questions that I think would be helpful for you guys out there. So I think typically what happens is that if for me, let me ask you a question. If an investor, whether it's a wholesaler or a rehabber, that's somebody new. Now they go out there and make an offer, and that the contract gets executed.
Yeah.
I think one of the things that I think a lot of new people get confused about is actually do they hold on to that contract until let's say it's a wholesaler, what do they do with that contract? Do they?
Sure. So one of the things that New Jersey has is what's called attorney review. So when you sign a contract in the state of New Jersey, you have a 3-day window to initiate attorney review. What that means is that you have, after the contract's executed, you have an opportunity to make amendments or changes to the contract. And as long as both parties come to terms on those amendments and changes, then you sort of proceed with the deal. So I get a lot of clients, when they get a contract, let's say it's a rehab or a wholesaler, and they got a listed property, right? And you get the New Jersey standard form contract. They always ask me, like, should I go ahead and sign it? What should I do? I don't, you want to review the contract before I sign. And whenever you have a real estate form contract, you can go ahead and sign it. That's considered the offer.
Okay.
That's not the final binding contract yet. So that's considered an offer contract. And then once the attorney review gets started and attorney review is done, that's when you're officially under contract, and then it's binding going forward.
Okay. So if you're dealing directly with the homeowner, let's say per se, and then what if and a lot of times I've seen this happen is that they go directly to the homeowner, and then they don't go see an attorney, they just hold on to the contract. Is that considered a binding contract?
Yes. So if there's no realtors involved, if they have a direct contract with the homeowner, and the homeowner doesn't have an attorney, or you don't have an attorney, nobody was what's called disapproves the contract within that 3-day window, then it becomes binding. It's a binding contract on both the buyer and the seller.
Okay. Now, is it the obligation of the person making the offer, whether it's a wholesale or whatever, do they have to say, hey, you should go see an attorney, or is that something that's...
So New Jersey is unique in the sense that it's not an attorney state. So for example, we have New York. In New York, for every real estate transaction, you're required to get an attorney.
Oh, really?
In New Jersey, you're not. But New Jersey is weird in the sense that everything north of the Trenton line, every real estate transaction is done with an attorney. Everything south of the Trenton line, people just use title companies.
Okay, so that's
and the reason being is that everything north of the Trenton line follows New York, right? So New York, you're required to get an attorney for every real estate transaction, so everybody gets it. Everybody south of the Trenton line goes along with what Pennsylvania does, which is a strictly title state. Nobody gets any attorneys. Everybody closes with just a title company.
Really?
So that's just you know, strictly speaking, in New Jersey, you're not required to get a real estate attorney. You know, you can close with the title company, but it's just the way the customs and like the norms in New Jersey have developed is that the northern half of Jersey every transaction has an attorney.
Yes.
And so, you know, even if you decide, hey, I'm not required to get an attorney, so I'm not going to get one, the other party is going to have one. So it's always in your interest to always have an attorney as well, because otherwise you're negotiating with an attorney on the other side, and you're automatically at a disadvantage at that point.
Gotcha. And so, but New York, you're required.
New York, you're...
Is it the whole New York State?
Yeah, whole New York State.
Gotcha.
You're required to have an attorney for a real estate transaction.
All right, that's good. That's good to know. I learned something new today.
Yep.
And I've been in this, you know, I've been doing real estate since 2004. Well, a little bit afterwards, but so I got some other questions. How would an investor, let's see, what are some things to keep in mind when going on the $500? So, right, I mean, I guess what are some things to keep in mind when going on the contract, whether you're wholesaling or purchasing as an investment property?
Sure. So a couple of things that you want to keep in mind. So we'll split this up into two different categories, right? If you're looking to wholesale the deal, what you want to make sure is that contract that you have, if you're direct with a homeowner, for example, is that you have the ability to sign that contract. There's what's called an assignability clause in that contract.
Okay.
That essentially just means that you, as a buyer, have the right to assign your rights to purchase to someone else.
Gotcha.
So if you're going to wholesale it, that's key, because you know you're going to go find an end buyer, and then you want to be able to transfer your rights or assign your rights to buy the contract to that end buyer.
Gotcha.
Right. The problem is if the contract is not assignable, then you're going to have to essentially buy that property and then sell it to an end buyer, which means you got to have the money to buy it first, and you got to pay closing costs and all of that stuff, and then sell it to someone else. But if the contract is assignable, you don't need to go through all of that. You just simply find an end buyer, and you assign the contract. You notify the seller that we're assigning the contract. This is the new buyer, and that's all perfectly legal because that contract has an assignability clause in there.
Okay.
So for a wholesaler, you want to make sure the contract has an assignability clause, that it is assignable.
Okay.
For a rehabber, things you're less concerned about that. Some of the things that you may want to be wary of is that a lot of times, let's say the property is called 123 Main Street, right?
Okay.
You're essentially, when you're putting the offer in and you get the deal started, you may not have a new entity formed for that deal yet, right? So, for example, you may be using your holding company. We'll call it, Paul Kim Holdings LLC, right?
Okay.
You may submit the offer because you don't know if this deal is going to go forward or not, so you don't want to form a brand new LLC for this transaction unless you know the deal is going forward.
Okay.
So, but obviously, you don't want to own and rehab the property under your holding company, right? You want to have a new entity for that. So you want to make sure that there's language in that contract that allows you to either assign or to close in a LLC yet to be formed. Right. So that way, once you get under contract and let's say you do your inspections and you're like, all right, this deal is good, I'm going forward, you want to form that 123 Main Street LLC and either sign the contract or have close underneath that LLC, because you don't want to buy it in your holding company.
Gotcha. Yeah.
So that's one thing to just make sure of at the onset. And the other thing as a rehabber is you want to make sure all of your your due diligence contingencies are there. Let's say you're gonna do a structural inspection, you want to do an oil tank sweep, you want to do whatever, let's say you want to figure out the zoning before you move forward, right? You got plans to make it a 2-family, or you got plans to sort of expand the house. if all of that is critical for you to be able to close on the deal, you want to make sure that that language is in the contract, that you have the right amount of time that you need for those inspections, for those zoning approvals, or whatever you need are mentioned in that contract. That way, let's say you find any structural issues or anything like that, you can either back out or negotiate with the seller. Be like, look, I can't go forward with these issues there.
Is the typical 14-day inspection clause sufficient enough for that, or do you put more explicit language in there?
So a lot of times when you're buying a distressed property, right? A lot of these properties are distressed, which is how you get a good deal, right?
Right.
They will always, the seller side will always strictly try to make everything as is. Like I'm not going to do anything, and so that's one of the other things that we'll eventually talk about, is that the difference between what as is and
that's one of the questions I got.
Right. So we'll talk about that, but you want to make sure that your inspection rights are not limited, right? Because the seller at the onset keeps insisting everything is as is. You want to make sure that they don't take away your inspection right. You want to make sure you have the 14 days, and you want to try to not limit that as possible. But sometimes if it's a good enough deal and it's a distressed property, you can sort of compromise with the homeowner and say, look, I want to do inspections, but I'll limit them only to major things, structural, environmental, or just strictly mechanical. I'm not going to nitpick little things. So if you want to do it as is, look, but I want to keep at least these minimum inspections in place.
Okay, so we'll talk about that as is clause, because that actually, that's something I have a question of.
Sure.
Now, with regard to let's say you're buying a buy and hold property, is there any other thing that you would consider that consider?
If it's going to be a buy and hold property, one of the things that you want to really be keen about is what the tenancy laws or what the tenancy regulations are in that town, what the rent control regulations are. You want to make sure that the property is, let's say it's multifamily, that's what you're going to buy and hold, that is properly zoned for that is properly registered, because you get this all the time where it's legally a 2-family, but the previous owner has been using it as a 3-family. They've been illegally renting out a basement or something, right? Okay. You want to make sure that all the zoning is what you need it to be. And second, you got places like, for example, Union City, which have very strict rent control regulations, right? Where, for example, and I'm using Union City because I got a deal right now where a client is now coming to me because they bought a property in Union City as an investment property, and they only found out after the closing was done that if it's not owner occupied, it becomes subject to rent control.
Really?
The previous owner that was selling it lived in the property, so it wasn't subject to rent control. So he said, hey, the property is not subject to rent control. And the guy and my client now is trying to get this rectified, bought the property thinking it's not subject to rent control. This is great. I can buy the property and I can rent it for whatever.
So that's an important consideration when you buy and hold.
Right. Then. Yeah, because now this person is, they bought the property. They didn't buy it as a primary residence. They didn't buy the property. They bought it strictly as an investment property.
Right.
So once they did that, it now was no longer exempt from rent control. So now all the units became rent controlled.
How many units?
It was a 3-unit, okay. Right? So it was a 3-unit. So they all became rent controlled, and now this person is like, what do I do? I didn't expect this. This is going to really hurt my bottom line.
Yeah.
So but if they had done the due diligence beforehand and went to Union City and found out, what are the rent control regulations, what are the requirements, they would have known that before they bought the property, and either restructure the deal to maybe have one of the units be where they lived, or just said, what, because of this, I need to work out redo the price.
Yeah.
Because it doesn't make sense at this price.
Right.
So all that kind of stuff is for a buy and hold. You want to make sure you know ahead of time. You don't want to figure this out after you bought the property and now you're like, I can't raise the rent on these tenants. You want to get as much history from the owner on these tenants as possible. Where we live, especially in these urban areas, like I said, you got between Newark, Jersey City, Union City, all those places have very favorable, sort of 2 tenants regulations, but also, you want to, if you end up in landlord-tenant court there, you want to know what to expect. So you want to sort of make yourself as informed as possible about everything related to tenancy in those towns.
Gotcha. Wow. Okay, that's good. So this is a good question, actually. If the seller doesn't have any attorney, can you represent both of them?
No. Technically speaking, if both parties sign a waiver of conflict, you technically are allowed to, but I or many other attorneys would still never do that. It's just, it's a real estate transaction, and there's going to be so many conflicts of interest. There's going to be so many, adverse positions on both sides that are going to pop up that you cannot adequately represent both parties. So it's just not, as an attorney, like I said, it's not worth the risk to me to get into that situation.
Gotcha.
And I think most attorneys would be of the same opinion, even though technically you can, as long as you get everybody to sign off on everything. It's just the nature of the deal is going to be inherently, there's conflicts all around.
Gotcha. Yeah.
So I would never do it. Most attorneys would never do it.
All right. So my next question is the as is. So if you buy the property as is, and even in my, for myself, and I always say, hey, I'm buying the purchase as is. So maybe my interpretation might be different from what you're going to tell me. So hopefully you clarify. So what does that mean, in terms of inspection and,
Sure. So this comes up a lot. Everybody assumes, so what I'll start off by saying is that unless there's an explicit warranty that the seller gives you at the onset, every deal is always as is. To give you an example is if you're buying a used car, right?
Yeah.
Let's say you go to your corner used car lot, right? You're not going to, you're not buying a certified used, but let's say you're just buying a used car. The car is sold as is.
Nice.
You're not getting any, warranties with that car. You're buying a 10-year-old car. It's, you sort of take on the risk of whatever comes with it. So buyer beware. Do your inspections on it. Do your due diligence on it. And if you buy it, it's on you.
Right.
So everybody always, especially in distressed properties, every seller is like properties as is. What that just means is that seller's not under any obligations to do anything, right? That doesn't mean no matter what you find, you got to buy the property as it is, right?
Okay.
So there's a difference between waiving inspections and buying the property as is.
Okay.
Right. So as is just means the seller's telling you up front they're not intending on making any repairs, doing anything to the property.
Okay.
But you can have it as is property with your inspection rights still intact. So
Gotcha.
you can still conduct an inspection, and let's say you find something and you notify the seller. The seller can say, look, I'm not making any repairs. It's as is. You can decide, well, you're not going to make any repairs. The deal's not what I want to cancel.
Right.
What you want to be aware of is if the as is comes along with you waiving your inspection contingency, you don't want to do that. I mean, sometimes if the deal is good enough and you know about the property and you sort of check it out beforehand and the seller is insisting and it's a good enough price,
right,
maybe you'll waive your inspection because you know what, you've done enough due diligence ahead of time for you to sort of move forward with it.
You're getting a good deal.
You're getting a good deal. So
yeah.
even if let's say something does come up, you sort of you got a cushion in there, right?
Yeah.
But so bottom line is, if a contract says property sold as is, that doesn't mean you're waiving your inspection right. That doesn't mean you don't have an opportunity to inspect.
Gotcha.
The only time you actually give away your inspection rights is if you explicitly waive inspections. If you either cross out the inspection language in the contract or you specifically state all inspections are waived.
Okay. So another question that I have is as a wholesaler, just in terms of transaction-wise. So let's say you make an offer, right? You have a 14-day inspection, and then you find the other buyer. Now, my assumption is that contract carries over to the end buyers who's going to be assigned the contract.
Right.
Is that correct?
Right. So the contract, you're assigning all your rights under the contract, which means all of the terms that you agree to with the seller also get transferred over to them.
Gotcha.
So for example, let's say you do have a 14-day inspection contingency in the contract.
Yeah.
And let's say on day 4, you sign the contract over.
Right.
That means that person, the end buyer, only has 10 days to conduct their inspection.
If they have a 10-day.
Right. If whatever is left on that. They don't get a brand new 14 days from when you sign the contract over to them. They got to take over everything you have with the seller exactly how it is.
Gotcha.
So everything starts when you go officially under contract. So let's say it's 14 days. It's either 14 days from when you finish your attorney review, or if it's there's no attorney review involved, there's no attorney, you just sign a contract with the seller. 14 days starts from the day you sign the contract.
Gotcha.
But that starts counting, and that doesn't pause while you go find an end buyer to assign it to.
Yeah. So you got to make sure that you find the buyer.
Right.
Okay.
Right. And then everything is negotiable, right? So let's say you're like, look, I'm gonna need some more time to market this property, and you can negotiate a 20-day, let's say, inspection window with the seller. And if the seller agrees and you agree, then that's what it is. It's 20 days.
Gotcha. Now, for those that are watching, if you have any questions, put those comments below, or on Facebook Live, you can put them on comments below.
Yep.
And I'm sure Fawad will get to them, or if I know the answer, I'll try to get to them.
Yeah.
So I submitted. So this is another good question. So then actually, I actually had this question myself. Is that you tell the seller, hey, I'm going to buy all cash, but you're going to get hard money, or you're going to get an end buyer that's going to get hard money. So how do you what if the end buyer is getting hard money, but for whatever reason, there's that slim possibility that they can't they can't get financing. And so how do you deal with that?
Sure. So with that, you gotta, like, if it's a cash deal, there's no financing contingency in there, which means that so if it's a cash deal, you're allowed to go get financing. There's nothing to stop you from going to get a loan on the deal. But what that just means is that if your loan gets denied, you still have to go forward with the deal. There's no protection, meaning, hey, you can't go back to the seller and say, look, I got denied my loan, so I can't move forward with the deal.
Right.
Because you already told the seller you're buying cash.
Mm-hmm.
So when you buy something cash, you always have the option to get financing, as long as it doesn't either delay the closing or terminate the closing if you get denied or anything like that.
Gotcha.
So that's something that you really want to, if you're buying to rehab, you want to make sure you have your hard money lender that that you've already vetted everything out with, ready to go, that you've given them some of the preliminary numbers, so
mm-hmm.
And they sort of said, yeah, we can do a deal at those numbers. Obviously, any hard money lender is going to do a appraisal on the property. They're going to run, they're going to get actual numbers and everything. But as long as you're giving them look, I got this deal, I'm about to put an offer in on it, can you fund this deal for me? And, most hard money lenders will be like, yeah, we know you, or, yeah, give us some basic information, and we'll say, yeah, we can do a deal at these terms or not. And then, you move forward with it, because you got to be careful, because if, let's say, you get under contract and you find out, 20 days in, that your hard money lender is now saying, I can't do this deal, the numbers don't make any sense on this, then you're stuck. They got to buy cash or scramble to find another hard money lender, or find another way to close.
Gotcha. So as a wholesaler, then, because, as a wholesaler, when you make an offer, most of the time you present a all cash offer.
Right.
And so I guess ultimately then you're only, you really have to utilize that, from my point of view, you really have to utilize that inspection period to really up or down on that,
Right.
offer.
So if you want to, that inspection period for a wholesaler, that due diligence period is very crucial.
Yeah.
Because, that's your opportunity to be able to back out of the deal if nothing can come together on that.
Gotcha.
So you really want to pay attention to that. You want to try to get as much with the seller. You negotiate with the seller. You want to get as big of a window as the seller will possibly agree to. That way you have the most amount of time, and then pay attention to that, because let's say you're marketing the property and you're just like, I'm not getting any interest at all. Maybe I'm at the wrong price point or whatever.
Yeah.
And you're getting close to the end of that window, and you're just like, I don't have any bites, no interest, none whatsoever. This deal may be a dud. So you want to be able to sort of cancel during that window.
Right. That's what I tell wholesalers that are, whether you're starting out, is that you got to know your market. You got to know. Yeah. You got to know. When you get a deal, accept that that you can. Because I think most critical for me is like having that handful of end buyers that I know are going to purchase that.
Right.
You know what I'm saying?
Right. That's it. Yeah, you as a wholesaler, you really have to build up your network of people that you can bring deals to.
Yeah.
And I've had this happen too. I've represented wholesalers that are brand new to this game and to this industry, and they've essentially closed a wholesale deal and made zero, because they miscalculated what an end buyer was willing to pay for that. The price point was too high on their sell side, with the seller. Mm-hmm. They're not able to work in a cushion for them for the wholesale fee. But for them, they'll close without making any money, because it's their first deal. They get their feet wet. They get to realize what it is, and plus they also want to build rapport with these cash buyers. Right?
Exactly.
Right. So they'll still do it, but they miscalculated all the numbers.
Yeah.
Right.
Gotcha.
So you really have to know that market, you really have to know what things are going to go for. So do your research in that market, do your research on that house, and it's easy enough now with everything being online. These wholesalers can find their own comps, right? See legitimately what the ARV is going to be.
Yeah.
And so that way you sort of don't cut your legs out from underneath yourself before you get it.
I've done my share of getting like my small fee.
Yeah. No, I mean, like I said, I've seen as low as zero, right? Like a wholesaler's literally closing the deal with zero. So it's just that's just part of the game. Sometimes you win, sometimes you don't.
Yeah.
But just go in as informed as you can.
All right, so let's move on. So after my due diligence, so after, let's say, due diligence, how do I, if I decide that I don't want to move forward, how do I get out of the deal? I guess that's where you come in.
Right. So we basically would send, you obviously these properties, are not in great condition to begin with.
Yeah.
Right? And as long as you preserve your inspection rights, there will be issues that are present that are at the property.
Yeah.
So you basically just you send a notice of termination to the seller, seller's attorney, or to the seller, notifying them, look, as pursuant to the inspection contingency, we're going to terminate based on the condition of the property or the issues found. And like I said, most of them are in terrible enough condition where you can easily name off some major issues with the property.
Yeah.
And you terminate and you move forward. One thing to keep in mind as a wholesaler is that usually you need to give a deposit on the contract, right? As a wholesaler, you want to try to negotiate with the seller to be something minimal, $1,000, maybe a couple of $100, just to have a deposit on the deal.
Mm-hmm.
So you obviously when you get an end buyer, you collect a deposit from them to sort of make sure if they back out, that you don't lose all your money on whatever deposit you put down. But the key to this inspection phase is that if you do end up canceling, you want to legitimately cancel, so you get whatever money you did put as a deposit back. Let's say it's $1,000.
Right.
You want to be able to get that back.
Okay.
Because if you don't cancel, and let's say you're out of the inspection phase, you sort of lost the protection of the inspection contingency, and you cancel at that point, at the very least you're going to lose your deposit. Depending on the seller and the seller's attorney, it can get more aggressive than that, where you're like, look, you know what?
They go after you.
Well, so this is the thing. Technically, yes, they can go after you.
Right,
There's a breach of contract,
yes.
right? Seller can go after you for damages. Damages including, you're going to buy the property for $100,000, and now they need to go find someone else to quickly buy it because they're trying to sell this property, and they can only find somebody that can only buy for $80,000, right? So now they're going to claim that as loss, right? I was going to get $100,000 from you, and since you backed out and you breached the contract with me, all I can get is $80,000. So $20,000 is my damages here.
Right.
Go after you for that. Now, that being said, most of this stuff, if it's small enough damages, because it's going to cost them money to sue it,
yeah.
stuff, right?
Yeah.
So most people just settle on losing the deposit. I'll keep your deposit, and you go your way, I'll go my way.
Gotcha.
Majority of the time, that's what happens.
Okay. Another question, when you talked about deposit, so when you're making an offer, whether you're directly making an offer to a homeowner or to an agent, who do you make out the deposit to?
So there's two different types of deposit. One's the initial deposit, which is a good faith deposit or a contract deposit, and the other thing is an additional deposit.
Okay.
A lot of times, let's say you're working with a homeowner directly, you can put that in the contract, and everything is done based on the terms of the contract that you guys signed. It can be, hey, look, within 10 days of executing this contract, I'll provide $1,000 deposit.
Okay.
You can work that into the contract. Same thing goes with the if there's a listing agent or if there's a realtor involved, right? If you look at the standard form contract on the first page, there's a line for initial deposit, and there's a line for additional deposit.
Yeah. Mm-hmm.
The initial deposit, if there is a dollar amount there, is what the realtor will collect from you when submitting the offer.
Okay.
Right. So that's called a good faith deposit.
Okay.
Where you're showing to the seller that I'm in good faith looking to move forward with this deal. Here's $1,000 to show that I'm serious about it, and that's due when you submit the offer.
Gotcha.
The additional deposit is usually due at whatever term usually everybody agrees to. Typically, that's 10 days after attorney review.
Gotcha.
Within 10 days is when the additional deposit is due.
Okay.
Again, all that stuff can be negotiated. You can drag it out to 15, 20 days, whatever all the parties agree to.
Okay. And the initial question is, do you write the check to the seller's attorney, buyer's attorney, the agent, or homeowner?
Yeah. Usually what happens is that the standard, again, there's no sort of requirement that one holds it over the other. Standard in Jersey usually is that the seller's attorney holds the contract deposit.
Okay.
But again, that can be negotiated. It can be that, hey, I want my attorney, the buyer's attorney, hold it, and as long as the seller side agrees to that, that's also fine.
Okay.
If you're working with a realtor, that initial deposit usually gets paid to the realtor's brokerage.
Okay.
And during attorney review, parties agree that all deposits will be held, let's say, by the seller's attorney. Then the realtor hands that over to the seller after attorney review is done.
Gotcha. Okay. Got it. I was gonna say, do you give it to the homeowner?
No. So usually, if the homeowner has no attorney, the homeowner is not proceeding with an attorney, which again, they're not legally required to have an attorney. Let's say they decide not to, then you just have your own attorney hold it, or let's say you're using a title company. You have the title company.
Of course, title company has to get involved.
Exactly. So you can have your title company hold it. You should never just give it directly to the homeowner. That's not a good idea. You want somebody that has some sort of accountability.
Yeah. All right. So let's see. I got two more questions. Title issues.
Right.
Okay. And so I guess out of many transactions that you've done, I'm sure you've done tons out there.
Yeah.
What are some of the title issues that you see that pops up a lot?
So a lot that I see, because like I said, I focus a lot on investment clients, is that a good deal source for them is probate work, right? Estate work.
Okay.
Right? You get somebody that passed away, their family's like, look, I don't want to deal with the property, I want to sell it. So you're buying a property from either a deceased person or from an estate.
Gotcha. Yeah.
A lot of investors look for those because those are good deals, because the homeowners passed away, the family doesn't just want to liquidate the property, and they just want to get whatever they can for it.
Right.
So with those, there's a bunch of title problems that come up with estates, because most people, they don't know what let's say their father or their mother who passed away who owned the property, they don't know what they had out there, right?
Yeah.
They could have had outstanding liens and mortgages that they never knew about. The other thing with estate is that a lot of them don't know that you have to start probate, right? You have to open up probate. I think we had a deal.
We still have a deal.
Yeah, it's still going, right? where they don't realize that a probate has to begin. You have to open the estate.
You have to open it, and it has to close.
Right, exactly. Like well, so you have to open the estate, and then the asset gets sold from the estate.
Yeah.
A lot of times they think, let's say you have a son and the father passed away. The son is saying, all right, well, I'm his only heir, so the property's mine, and I'm selling it. Right?
Yeah.
So you have John Doe Sr. that passed away, and John Doe Jr. is like, all right, I'm gonna sign the contract. I'm selling the property. That doesn't. He may be entitled to the property, but he doesn't automatically just get it unless the father deeded it to him or his name is also on the deed. Most of the time, it has to open title. You have to go through probate, and then the son may be the executor of the estate, right? The estate of John Doe Sr. And the administrator is the son, John Doe Jr.
Right.
And he's selling the property. He can sign it, but the property is owned by the estate. The estate sells it. So probate has to be open. So you run into a lot of that. You run into a lot of tax lien stuff, right? So distressed property means they don't have money, they haven't paid any taxes, they haven't paid their mortgage.
Are you talking about property taxes or like state taxes?
Property taxes. Well, both, right? Sometimes you get both. Sometimes you get property taxes, liens on the property, and then you also get IRS liens on the property. So all of those things are things that need to be addressed prior to closing, right? Yeah. So let's say, for example, it's a tax lien, and a lot of times what happens is that if it's a tax lien, meaning what townships usually do is if there's past due balances on taxes, they auction it off, just like you auction up a property at sheriff's sale, right? Towns have tax lien auctions. Right. An investor will come in and buy the tax lien. And then so, those need to be what's called redeemed, right? So you have to go through township and you have to.
It means paid off.
Paid off, yeah. So they need to be redeemed. They need to be, so you get a redemption statement from the township and get it paid off. Sometimes it gets a little complicated where, especially on a property that has no senior mortgage, right? Let's say it's just tax liens on the property. There's no bank that you owe money to.
Okay.
But all you had was just tax liens on the property. tax lien investors look for deals like properties like that. They buy the tax lien and then they start foreclosing on it.
Oh, really?
So right, so and I have a deal like that right now where the property is currently under tax lien foreclosure, where there's no senior mortgage on the property, just an $80,000 tax lien. An investor bought it and they started the foreclosure process on that property. And so what happens in that case is that once the foreclosure starts, then it is up to the tax lien holder, the investor that bought the tax lien, whether or not to allow a third party to redeem it. They can just flat out say, no, we're not going to release the foreclosure. The homeowner always has a right to redeem, right? So let's say I'm the homeowner.
Interesting.
I'm the homeowner. I owe $80,000.
Yeah.
When they started a foreclosure on me,
Mm-hmm.
I can at any point during that foreclosure come up with that $80,000 plus interest, penalties, whatever it is,
right.
and pay them off, and they have to get rid of the foreclosure.
Mm-hmm.
But if you're doing it as part of a real estate closing, you have a third party, which is going to be the title company that's now redeeming the tax lien,
Mm-hmm.
right? The tax lien holder, the entity that's foreclosing on the property, does not have to accept it from the third party.
Wow.
So sometimes they do that. Sometimes they'll just be like, no, we're not.
Because they want the property.
Because they want the property.
Yeah.
They want to foreclose on it. So let's
Yeah.
say, like I said, it's a $300,000 property. They have an $80,000 tax lien. They're like, if I foreclose on this, I get this $300,000 property for
$80,000. Yeah.
Right. So they don't want to.
Yeah.
And in that case, you have a couple of different options. You can either file a motion in court to have the court force them to accept the payoff and
Mm-hmm.
dismiss the foreclosure, or the homeowner, if he has the money, can pay it off and then sell the property.
Gotcha.
So and then IRS liens, a lot of them come up. Sometimes I've had people that have had $3 million IRS liens that now we're trying to sell a property for. A client of mine is trying to buy it.
$3 million?
$3 million. You'd be surprised. $3 million.
I guess the penalties and interest.
Penalties and interest. Yeah, and these people, they have businesses or whatever, penalty, all that kind of stuff. So the interesting thing about IRS tax liens is that you can always petition them to release the property from the lien.
Right.
They'll keep the lien, they'll keep the judgment against the person,
right.
But you can ask them to release that one property from that. Majority of the time they will. Majority of the time they'll, because
if there's no equity. I mean, I've done that on short sales where
right.
Because there's no equity.
There's no equity, right? So you sort of reach out to the IRS, and this is where having a good title company comes into play, right? Because if they're a good title company, they're being proactive about something. And I work with numerous title companies, and some of them will be proactive. They'll reach out directly to the IRS. They'll get authorization from the seller, obviously. They'll reach out to the IRS and submit a request to release the property. And like I said, majority of the time they're able to get the property released. Where it allows everybody to close on the deal. Obviously, the IRS is not saying we're going to waive it. They're still, we also owe us $3 million.
Gotcha,
But we'll release the property, so you can go ahead and sell that. And a lot of times, you have to prove to them that there's no equity left in the property. But that's always a possibility. So there's, like I said, when you're an investor, good deals come out of distressed properties. So distressed properties come with their own headaches and stuff. So having a good title company that can help clear up the title issues definitely makes a big difference.
Gotcha. All right. I think that's about it. I mean, we're rolling into about 45 minutes. If you have any questions, write those comments, and I'm sure Fawad.
Yeah, either Paul or I will jump in the comments, and we'll answer them as best we can.
All right. I want to thank you for
coming by.
Yeah, and then we'll do this again. And actually, Fawad, you have a title company in the same building.
Yeah, there's a really good title company on the same floor as us that we work together with for Tuna Title.
Yep.
And
I work with them. And what's that? What's her name? Is it Shelly or
Donna?
Donna. Is it Donna?
Donna Shaholi.
Oh, Donna. Yeah, that's how I'm thinking of her last name. Yeah, she is good. She's really on top. I mean, I work with a lot of different title companies, and I get, when somebody's good is that they're on top of things.
Yeah, they're proactive. A lot of title companies will just say, these are the issues, and just leave it up to everybody else. And other title companies will be like, all right, these are the issues, but this is what we're going to do to get them fixed. They'll take that extra step, right? Because at the end of the day, and this is my approach to a real estate deal as well, is that we're all in this to close that deal, right? So do whatever you can to get it closed. Title companies don't get paid until the deal closes. I don't get paid until the deal closes. Nobody gets paid, right? So don't just state there's a problem. Come up with a solution. Figure out a way to close the deal. So that's always the end goal.
Yeah, then we also got that scheduled with, hopefully she can come on and maybe, you know, ask.
I'm sure, yeah.
I got a lot of questions.
I'm sure, yeah.
All right, well, if you have any questions, write them down. And thanks, Fawad, for taking the time. And how can people find you? What's your website, your phone number?
My website is haklawfirm.com. And my phone number is 201-500-7522. You can shoot me an email, call me at the office, and get some deals closed for you.
Okay. Do you want to share your email, or you just
email is fkhan, FKHAN, @haklawfirm.com.
All right, sounds good. All right, thanks.
Thanks a lot, Paul.
All right.